Neva Rogers and her ex-husband, Kantrell Hires, had 4 children. On Friday, January 13, 2017, Kantrell and the 3 oldest children, Christian, Caleb, and Alexander, set off from Corpus Christi heading to Midland. Just after 6 in the morning on Saturday, January 14, 2017, they encountered bad weather right outside of Midland. It was near freezing, it had sleeted overnight, and it was raining hard. An F-150 driven by Luis Rangel Jr. was barreling down the road leaving Midland. Rangel's employer, Dancar Energy Construction, was building a natural gas processing plant at a remote job site outside of town. Rangel was heading towards Dancar's job site. At 6:36 a.m., Rangel was driving over 80 miles per hour. He was just a few miles away from Dancar's job site, though he wasn't due to clock in until 7:30 a.m. Rangel hydroplaned, lost control of his F-150, and careened into Kantrell's lane. Though Kantrell was driving below the speed limit, given the conditions, there was nothing he could do to avoid the crash. Kantrell, Christian, Caleb, and Alexander suffered fatal injuries. It would take hours for word to reach their family back in Mobile, Alabama. But when it did, Neva and her youngest daughter Elizabeth learned the devastating news that evening. 3 of Neva's children had been taken from her. Elizabeth had lost her brothers, sister, and her father. Neva needed to know why. After months of doing her best to try and answer the question, it felt like she had more questions than she had answers. One unanswered question loomed large. Why was Luis Rangel Jr. driving so fast, in such bad weather, so early in the morning on a Saturday, when he wasn't due at Dancar's job site for nearly an hour? That answer would take years of litigation to uncover.
My children, I would say, were the cream of the crop. They were all straight A students. Caleb liked to pretend like he didn't like school, but he was extremely smart. Christian loved drama. I call her the drama queen. Alexander was such a lovable person. He loved God, he prayed for everybody, and he loved sports, and he had a sweet tooth out this world.
Neva's goal in this trial was not to get rich. That was the furthest thing from her mind. Her goal was to pursue justice for the children that she lost.
And once I found out that he was on his way to work and that it was horrible conditions and that the company still wanted them to go to work, I felt like I needed to pursue legal actions to basically fight for my children because they were taken away senselessly.
And I can tell you that as a parent and as a lawyer, we were not about to tell Neva Rogers that her children's memories and their deaths were going to go in vain, that we weren't going to try to pursue this. And we knew that it was an uphill battle, but we weren't going to tell her no. One of the things that can't be underscored enough is that venue a lot of times drives the value of your case.
In this particular case, we were in Midland, Texas. Midland, Texas is known for primarily one industry, and that's the energy industry, oil and gas. A particular challenge we faced was helping jurors who more likely than not have a connection to that industry, helping them understand that you can hold members of that industry accountable for misdeeds, for their negligence, and that's not an indictment against the industry that you're working for. Another challenge that we faced in this case was that our client was not from Texas.
Jurors in this area are a lot about personal responsibility. And in this case, you had a driver and you had a company. And the claims against the driver were different from the claims against the company. And it's trying to convince a jury of those different claims. It's hard for them sometimes to differentiate because it's just just an accident to the jury. The area out here is, I would say, very conservative with regard to jury verdicts.
And our client was from a different background, both socioeconomics and race, than what was common in the venue.
Second thing that was an uphill battle, in my estimation, is that the defendants had hidden evidence. They first destroyed evidence. They took 40 bankers' boxes worth of documents during the case, took them out to a field and burned them that related to issues in this lawsuit. They also had servers full of information, and rather than search those servers to provide information that would be responsive to our discovery, they hid that information.
And we had an uncomfortable conversation with the defendant's lawyer where he suggested that those documents had disappeared. The next thing that occurred was the deposition of the defendant, Dan Carr, which I took, and its former CEO admitted that he had removed boxes from his law firm's office, taken them out to Cisco, and started a bonfire on his father's property. After the deposition of Dan Carr, we went to the court and we asked the court to require Dan Carr to gather all of the laptops, computers, and devices that it formerly owned. We asked the court to order Dan Carr to pay to have those devices forensically searched, and millions of documents were recovered, and that really became the key to our case. Ultimately, the judge, who we believe made the right decision, after many hearings on this issue and a lot of briefing and a lot of work on this issue, ended up instructing the jury in that case that the defendant had intentionally destroyed evidence and that the jury could, if it wanted to, presume from that that the evidence which it destroyed would have been harmful to the defense in that case.
You know, one of the things that we have always utilized is the benefits derived from looking at juries' impressions through focus groups and mock trials. And we did that here. And one of the things that we realized was that we were going to have to get very realistic about what the strengths and weaknesses of the case were. And without going into great detail about what we saw in our focus groups, I'll tell you this. We were going to have to sort of reformulate what the emphasis of the case was.
Some of the things they talked about in their caucus group was pretty stunning to lawyers that don't practice out here all the time, among the really, really conservative bunch of folks out here. But it was a good thing that we did the focus group, because I think it helped the plaintiff's lawyer team kind of adjust some of their strategies.
What we found is that the citizens in Midland County not only embraced the concept of personal accountability, personal responsibility, but they embraced the concept of corporate responsibility, corporate accountability.
The key to the case was to shine a light on the corporate conduct that we think played a role here. It wasn't simply a man, as it turns out, driving 87 miles an hour in bad weather. There was a reason why he was doing that, and the reason was the subject of the cover-up that we ultimately discovered. So that was the first thing, and that was a huge issue in the case in pretrial. The second thing had to do with certain evidentiary rulings surrounding what I would call character type evidence. The defendants seemed to be hard pressed to do whatever they could to denigrate our client, which I think it's pretty infuriating and insulting to, on the one hand, say, you know, we're not responsible for the deaths of your children, but then also in the same breath essentially say, you know, you're a bad mother, or imply that, or you're a bad person, which Neva is none of those things. So what they had done was ginned up information that had been slung in a divorce proceeding to try to use that against her. So we were really sitting wondering what the court was going to do with that. Ultimately, she did not let that come into evidence. So that was a real key decision in the case. And then one of the other key issues was we had a really tough call to make concerning the pathologists who had performed the autopsies and who had made determinations on the cause of death here. There was clearly pain and suffering on the part of at least 2 of these children. It was hard because Neva had never been told that, and we had to explain to her that she's going to hear evidence at trial that her kids didn't die instantly. Certainly 2 of them didn't. But the problem was the sponsoring witness, who was a medical examiner of another county, was in the midst of a scandal. And it would have really hurt us to put him on the stand and subject him to things that really had nothing to do with our case, but called into question, right or wrong, his credibility as a witness. And so we had to make the very tough decision at trial whether we would fade the heat, not call him, and essentially use information from the autopsy reports to argue pain and suffering. And we did that gamble, and it ultimately paid off. The jury awarded pain and suffering, and the court let that information in.
I remember when Mike called me about this case one night and told me that we were gonna file it. And the next day, I had to get on the phone with Neva and walk her through what the process looked like. And I pretty much talked to Neva on a regular basis for the next 3 years as we marched this case through the system.
He is the reason why I had a court case. Meaning, by winning summary judgment, I could move forward with my case. Yeah, so Stephen's like the MVP of the firm. So, yes.
It was always such a great responsibility for us to shepherd this case to trial for her. And every time I had to pick up the phone and tell her about the next twist, the next shoe to drop with the defendants, I was always worried that she was going to finally reach her breaking point, and somehow Neva just doesn't break, and it's remarkable.
We had kind of ground zero. My attorneys stayed at a house, and that was our war room, our war house, if you will. And a colleague and myself, we drove up to Midland 2 days before everybody else was supposed to be there. We unpacked all of our boxes. I essentially set up a satellite office. So we had a printer, a scanner. We had some laptops that I had to set up. I had to set up areas for each one of my attorneys with their witnesses and all of their trial materials. I tried to make it as organized as possible before they arrived so that it would be a seamless transition when they arrived. I mean, and that was just the work aspect of it. You know, we also went to the grocery store to make sure everybody was, going to be fed and had plenty of coffee for the late nights.
Let me just say this, them being in the house and choosing to stay in a house as opposed to a hotel that was a block and a half from the courtroom, that had room service, that had a restaurant down below. They thought the best idea was to be in an environment where they could isolate themselves and be the team that they turned into during the trial. They sacrificed for the betterment of the team, for the betterment of their client, and I think that's something that's very, very admirable.
And I'll tell you that voir dire, so when we were vetting our potential jurors, Mike Lyons gets up before these folks, and you can tell he is so charismatic, empathetic to the situation, so relatable, and you can see it in the reactions of these potential jurors.
One of the things also that happened in jury selection was we were going to try to set the tone for the fact that Neva didn't have custody of her kids. And in looking over the jury cards, all the questionnaires that people had filled out, we started identifying people who were divorced with children. And there was one man in particular who was on the third row, who was over to my right. And I saw that he was an insurance claims adjuster for Progressive, which was the same insurance carrier that Mr. Rongel had. So I knew there was no chance he was going to end up on the jury. And so I took the risk of asking him some questions which may offend him, but could educate the room and ultimately, hopefully, swing people back in our favor on this issue. And here's the issue. Can a person who doesn't have managing custody or primary custody over their children still grieve the loss of their children if they die. I know it sounds silly, but so many people, when we focus group the case, gave us information that gave us some skepticism about how that would be handled. So I asked the room, is there anybody here who is divorced? Okay, put your hands down. Is there anybody here, by show of hands, who is divorced with children? Okay, put your hands down. Is there anyone here who's divorced with children who is not the primary custodian? About 3 or 4 hands go up, and this guy's hand is up. So I gambled right. So I stood him up and I asked him, what do you do? Of course, I already knew. And I said, let me ask you a question. If I were to tell you that because you don't have primary custody of your kids, because they reside with your wife, that you simply don't love them as much as she does, would you agree with me? And he said, well, no, I wouldn't agree with that. I said, the fact is that whether your kids live with you or live with your wife, that doesn't comment on whether you love your kids, does it? He goes, no, it doesn't. And I said, anybody that would try to make that argument, they would just simply be wrong. He goes, yeah, they would be wrong, because that's offensive, isn't it? It is. And I said, well, let me ask you this. I said, doesn't it make it all the more important, like the limited time that you have to spend time with them? He goes, yes. I said, so that time is precious. It's time that you look forward to, right? Because it's the time that you get them, right? He said, yes. And I said, if I took that time away from you and said, you're not going to get to see them, would you be sad? He said, yeah, I would. They're my children. So I then said, is there anyone in the room that disagrees with him? Raise your hand, and no hands went up. Everyone agrees that just because you don't have custody of your kids doesn't necessarily mean you're a bad parent, doesn't necessarily mean that you don't love your kids. So we nullified that issue, I think, because once we got to trial, it seemed like a non-issue.
And so then when we started trial, emotions were high. This is a very inflammatory case. You're talking about 3 deceased children, terrible circumstances. And I'm trying to think about how can we convey the gravity of the situation without being graphic, without being gory, because it was a terrible, terrible scene. How do you do that? How do you do that? Well, I'll tell you how you do it. You get my 4 attorneys up there who all have an emotional vested interest in this case, and you have them convey that to the jury.
Trial starts in earnest on a Monday morning. Chris Carr does the opening statement. I'm on pins and needles watching him give that statement, and he killed it. He did such a great job.
I will tell you what I told the jury almost first words. I was nervous simply because I cared about the case and my client so much that I didn't want to make a mistake. And I was also nervous because when you're a lawyer, you take these cases personally if you're doing a good job. But you realize once you get to trial that very soon you lose control. And you're going to have to give that case to a jury. So you want to be really deliberate in all phases of the case. You want to be very prepared in all phases of the case. And you want to make sure that you are giving an honest, complete, and full accounting of the case and the evidence to a jury, so a jury can do what it does best, which is make a decision that is unbiased, reasonable, and based on evidence.
At trial, there were some Perry Mason moments. One of the big ones was we had made a difficult tactical decision not to depose Luis Rangel for a 3rd time. In other words, they had successfully hidden this information in a way that we had the tough decision to make. Do we depose Mr. Rangel and ask him, were you on the road because of this policy? And then risk him saying, no, I wasn't, whether that's through some type of coercion or coaching or maybe on his own self-interest, and risk a summary judgment that prevents us from getting to a jury? Or do we ask him cold on the stand and cross-examine him? And so that's what we did. And that task fell to me. I cross-examined him. I got him to admit that he was on the road that morning because of the policy. He was driving fast because of the policy. And there was another moment with Mr. Rongel, that I thought was critical was I asked him if he was aware of the strategy that was being employed in the case by the defense lawyers. And he sort of looked at me like he didn't understand what I was saying. And I said, do you understand that these lawyers over here are going to blame you for this? They're not going to take any responsibility. The company's not going to take any responsibility. This is all going to fall on you. Do you understand that? And, of course, they're objecting and everything else, but the jury heard it and he heard it. And I think it was for the first time, maybe in the whole case, where you understood that he was actually being scapegoated. When we picked the jury in this case in voir dire, I told the panel, as a Texan, I feel like personal responsibility is one of the most important things that we have as citizens. You're accountable for your actions. Mr. Rongel should be held accountable for his actions. But just because you're a company, a non-natural person, you don't get a free pass. Corporate responsibility is just as important as personal responsibility.
I think we demonstrated to the jury in that case that the corporate defendant, Dan Carr, had made a conscious decision to remove a policy that would have been protective of the public and of our client's family and replace it with a policy that created a hazard on the roads. And we started cluing into this when there was a policy missing from the employee policy manual that we were given, but there was a heading that remained in the table of contents. And they took a policy that would have allowed and empowered their employee who got on the road in awful conditions, icy conditions, dangerous conditions, as he testified and as a trooper testified, lost control of his car and killed a family. They took a policy out of the manual that would have empowered him to call in and tell the company he couldn't drive in that weather and they would pay him half his wages. And they replaced it with a policy that required him to be on the job site by the time they called the job for weather or he wouldn't get paid. So we thought it was a perfect demonstration, both of a company making a horrible decision for financial gain and putting dollars over people. And that to me was a real highlight in the trial.
There was some real angst about Neva taking the stand. She had to testify on her behalf and relive what to any person would be the worst experience of their entire lives. I have often reflected during the course of that case that if I had to bury one of my children, I don't know that I could go on. I can only imagine what it would be like to bury 3 children, which she did. And so Chris Simmons, who is a gifted lawyer, also a great human being, so he connected with Neva in a way nobody else could and got her prepared. He made some tough calls. He did a great job of putting her on the stand, and let me just tell you, it was some of the most emotional, gut-wrenching testimony you've ever heard.
That is a moment in my career that I will never forget. The grace and the courage that Neva exhibited from the witness stand was absolutely remarkable. You're talking about a woman who has lost 3 of her 4 children, having to sit through days of testimony and evidence. And then she had to listen when the defense suggested to the jury that if the jury was willing to award any sort of monetary damages for the lives of her children, then they should consider awarding a couple of $100,000. So after hearing all of that, when Neva took the stand, it was her opportunity to talk about her 3 children. It rocks your soul when you see a mother talking about picking out headstones and coffins for the children that she's raised. And it'll shake you to the core when you see a mother crying to 12 strangers on a jury as she relives how much she misses those 3 babies. Neva did all of that. All the while, she made it clear to the jury that although her children had been taken from her, and although there was a man and a company at fault, she had forgiven them. And I think that mattered to Neva, so that she could heal, so that she could find closure. And to me, that was telling, that Neva was able to forgive, but she understood that there's an obligation, and she felt it, to pursue change so that somebody else didn't have to walk in her shoes someday.
I think when Neva took the stand, the air in that room was electric. I mean, Neva is an incredible individual, and she has been carried by conviction and faith alone. But hearing her tell the jury what the day she found out she'd lost her children, the weeks she spent trying to figure out exactly what happened, her journey quite literally from Alabama to Midland, Texas, to retrace their steps, to talk to the EMTs, the doctors, about what had happened. Everyone was moved.
I looked over at the judge who was fighting back tears. I looked over at the jury, and I believe we had 5 men and 7 women, if I'm not mistaken. There were 2 Kleenex boxes, one in the front of the panel, one in the back, and both of them were being passed around because no one had a dry eye. It was so sad.
It's a little bit different when you're on the witness stand, and I just didn't want to talk about what I had to talk about, but I did, and I talked about it, and there was no way for me not to get emotional talking about my children, the last time I saw them, and the things that we did. Yeah, it was very challenging.
I knew that there was a good chance that we were going to close the Friday before Mother's Day. I had thought about this, thought about how I was going to keep it together, really. As a father, I have 3 kids. I kept putting myself in the shoes of my client, and I know sometimes that can be really dangerous. But I think it helped me gain perspective and to really channel the pain and to channel the anger of how this had played out and how it happened. I made the decision that I was going to wear a pink shirt. I walked through the evidence, and I was told by our local counsel, a guy named Dennis, who's in Odessa. Dennis had said, "Mike, I know that you plaintiffs' lawyers like to get up and fill in the blanks for the jury and tell them exactly what to write in." He said, "Don't do that here. Jurors here in West Texas don't like to be told what to do." And so I said, "Duly noted. I won't do that." Opposing counsel got up and made the mistake. He wrote in numbers. So when I got up to rebut that, I simply said that Dan Carr should be ashamed of themselves, that they should be ashamed of themselves to suggest to you that $50,000 would be an appropriate award of damages where 3 children died. And I said, let me tell you what he's asking you to do. He's asking you to either ignore their conduct and give them a free pass and say no negligence. Or worse yet, if you think that this policy is a bad policy, he's inviting you to find negligence, but to not require them to pay for it. And I said, in my mind, that's more dangerous than simply pouring the plaintiffs out. Because if you find negligence on the company and you don't require them to be held accountable by awarding damages, then every single person who is in the oil field, every insurer, every company, is going to high five and say, you know what, we can be negligent. A jury can literally find us negligent of killing people, and they're not going to award damages. So what do we got to lose? So I made that argument, and then I said, you know, I'm wearing a pink shirt. Some of y'all may be wondering, who's this Dallas lawyer in a courtroom in Midland County wearing a pink shirt? And I said, it's a tribute to the moms everywhere. It's a tribute to my mom, who I love, who, by the way, I haven't lived with since I was 15, and who I have a great relationship with, and would be really sad if I wasn't in her life and she wasn't in mine. But I said, it's also a symbol because Neva Rogers will never experience Mother's Day the way she should have. I want you to think about what her Mother's Day is going to be like on Sunday. She's going to leave Midland, she's going to go home. And do you think her Mother's Day is going to be full of joy? She's going to be thinking about her 3 kids who are dead. She's going to celebrate the one that she has, who is still grieving the loss of her father and her 3 siblings. She is going to experience that pain for the rest of her life, not just every Mother's Day, every Christmas, every Thanksgiving holiday, every one of their birthdays. It will never leave her ever for a second. So the reason I'm wearing a pink shirt is because that's what mothers do. They love their children unconditionally all the time. And Neva's no different. So it was an emotional plea to hold them responsible.
And I remember him looking at the jury and asking him, y'all probably are wondering why this guy's wearing a pink shirt. And he reminded them it's because it's Mother's Day. So, you know, again, good lawyering skills, but again, Mike knew how to talk to that jury, and Mike knew how to explain to them the suffering that his client went through, and that someone hopefully would be held accountable for that.
The jury was out for approximately 2.5 hours, and we got a note. Judge calls us back in and says, there's a note. And the note was, we would like to see the exhibits Mr. Lyons used with his damages expert. In lay terms, that means we've answered yes to the liability questions. So the question is, how much are we going to award in damages? I mentioned that I respected the defense lawyers. One of the other lawyers, who I thought did a great job, laughed out loud and smiled and looked at me and said, well, Mike, I guess it could be worse for us. They could have asked for a calculator. As soon as I walked out of the courtroom, my phone was ringing, and it was the mediator on the case saying that they wanted to enter into an agreement, essentially what's called a high-low agreement. And the result of that was that our client would be compensated no matter what. It capped the amount of money that she could get if the damages exceeded a certain point, but it guaranteed a certain sum. And it was a good result for her. And it frankly fit within the range of what we thought the case was worth. One of the other uphill battles about the case that I failed to mention is that we had a very conservative court of appeals, and our fear was that any plaintiff's award would be reversed on appeal. So as we were hammering out that agreement, the bailiff comes into the room where the lawyers are working on that agreement and says, we've got a verdict. And so we said, okay, keep them at bay. We're going to finish this agreement, then you bring the jury in. So we go in. The jury had been out from probably maybe noon until about 4:30. And they came back with a verdict. It was a 10-2 verdict. The 10 that had signed the jury card or verdict form had found negligence on both defendants. They awarded $6 million, essentially. The largest jury award in the history of Midland County in a personal injury case was $3.8 million, which has existed forever. So it was a big verdict for Midland County by Midland County standards.
The verdict was passed. The foreman read it. In those moments, you could see a wash of relief just pour over Neva. And it was followed by extreme emotion.
And Neva, who had held it together for over 4 years heard the same thing that we did. And the release of emotion that she had, I have goosebumps talking about it right now.
When Neva heard the verdict, it was an explosion of emotions for her. She was overwhelmed, and just watching her, I got shivers all over my body, and then I started to cry.
When the verdict came back, it was a great relief. It was great to know that we had done our job well and that our client had received justice. But at the same time, it was such a emotional, cathartic moment for Neva that we had to take care of her, because it was an end to a process that no one enjoys, but it's our job to help them through it. You asked me how our team functioned out there. It functioned flawlessly. There was not a member of that team on any given minute in that courtroom that I was not proud to be on. So from Stephen Higdon, the youngest lawyer on the file, who is a legal genius, a briefing wizard, and a tenacious lawyer, and fantastic orator, to Mike Lyons, who did a phenomenal job picking the jury. Closing argument in the case delivered by Mike was fantastic, as was Mike's performance at trial. Chris Simmons did an excellent job directing our client, Neva Rogers, through a very difficult time in the process for her. And then backing us up the entire time was our paralegal, Trish Melian, who is steadfast and a hard worker, and we couldn't live without her. So it was a team effort.
I got a phone call from a mentor and a colleague that I respect greatly. He had reviewed the transcripts from the jury selection, and he said that he wanted to nominate me for an award. Ultimately, our trial team was nominated for, and it was the John Howie Award that the Dallas Trial Lawyers Association gives out. The award is given out annually to the pursuit of justice in the face of adversity. And I'm just so proud about it. I'm proud because of what it represents. I'm proud for our whole team who received the award. What it represents is that this courageous woman, Neva, fought for her children and fought for justice for her in the face of tremendous adversity, and showed the courage to fight through all of it. And for us, we felt like we were just a vessel or a vehicle to kind of deliver her strength. And I'm glad that I took the journey. There were moments where I thought, this is no good deed goes unpunished. This case is not going to turn out well for us. There's going to be disappointment. I don't want to disappoint my client. I don't want to put something out there on paper that's a negative reflection of the firm because we took a tough case to trial. But my dad, who passed away in 2018, used to say, everything works out. If you just try to do the right thing, even if it's hard, it will work out. And that's what happened here. It's a great result after a really horrific tragedy.